concept. I'll just try to run over again. Last time we studied about judicial precedents, and now we will go through legislature. Generally speaking, there are three wings of the government. It's like legislature, executive, and judiciary. This is something you must know. So legislature is a body that deals with lawmaking. Law that is promulgated by legislature is referred to as legislation. Therefore, we can say that legislature legislates. Now, next, we have the executive wing of the government, which is headed by the president at the national, the federal level, and at the state, regional level, depending upon the demarcation of territories in the nation, it is headed by a government. And the function of the executive, the function of the executive is to implement the laws. Thereby, we can say that executive power vests in the president of that particular country or a nation. So therefore, there are three wings where legislature enacts laws or promulgates laws, makes laws, or even, you know, not interprets. It can amend the laws, or it can also repeal or abrogate the laws. Then we studied the function of, you know, the different wings of the government. We went through the definition of legislature. We learned about the US, how, you know, how is US set up, that it has, you know, it has the Senate, and it has the House of Representatives, and to enact laws, the consent of the majority of each branch of the legislature, and then it must be approved by the president. Then we went through UK, where Her Majesty the Queen is the constitutional head of the state or monarchy, and UK is a constitutional monarchy. They have the parliament there, and parliament comprises of the House of Lords and House of Commons. That's what we saw, you know, in the, you know, the first 40 minutes. Then we saw that the House of Lords basically comprises of Lords spiritual and Lords temporal. House of Lords comprises of Lords spiritual and Lords temporal. Lords spiritual are basically senior bishops of the Church of England, and Lords temporal basically consists of life peers or friends appointed by the sovereign or the friends of the Queen. So the House of Commons, on the other hand, it comprises of elected representatives representing 650 single-member constituencies. Now, the Prime Minister is part of the House of Commons, and Her Majesty Queen Elizabeth II plays a ceremonial role as the head of the state, and the country's executive branch is headed by the Prime Minister. In UK, unlike USA, all legislation must be approved by the House of Commons in order to become the law. So this is what we saw. Next, we spoke about Australia. That is, the Australian Constitution provides for three arms again, and they enjoy the doctrine of separation of powers. And I spoke about how the Governor General appoints even the judges of the highest court of Australia. 1 minute, I'll admit people, I'm sorry. Appoints the you know, judges of the highest court of Australia, which is the High Court in Australia. So that's how there is a kind of coordination between the two wings of the government, or two arms of the government, that is the executive and the judiciary. So then we spoke about India. We said India is a democratic republic, and you have the parliament there, which makes laws, and you have, of course, a parliament is that has the legislature, and it comprises of the Lok Sabha as a lower house and Rajya Sabha as a higher house. Then we spoke about Somalia being the federal parliamentary system of government, and then we said that the legislative branch of the government again is vested in the parliament, and the executive division vests in the federal government of Somalia. And again, there you have the parliament is bicameral, that means again having two houses, House of People as a lower house and the upper house. And in Somalia also it is a legislature which makes laws. Then we went through the concept of justifying and evaluating the law. We said how laws must be based on principles such as welfare of the people, fairness, equality, equity, liberty, justice, and so on. Then we said that there has to be, the marriage of the principle of beneficence and deontological concepts, or there are philosophers which believed in prescriptive thinking and they examined the marriage of beneficence, welfarism, and deontological concepts. So what is beneficence? Beneficence, that means attracting the principle of doing good pro tanto. Pro tanto means to the largest extent, that is as much as possible or to the best extent. So you should say that in your answers when you're writing, saying that while making laws, there are certain principles to be considered, such as the welfare of the people, fairness, equity, liberty, and justice. Some of the philosophers, they are prescriptive in thinking, and they examine the marriage or the union or the benefits of, you can even put it this way, the benefits of combining the principle of beneficence, that means doing good pro tanto, and welfare of the people, and deontological concepts. Deontological theory basically is an ethic theory that distinguishes what is right from what is wrong. In the present context, in the world, the right-wrong theory is much reflected in the laws. However, what is right and what is wrong differs from one jurisdiction to another. So this is what we discussed. And apart from that, constitution of the land, any law that is made should not hit against the constitution of that particular country. Anything that is unconstitutional can be struck down as bad, and thereby it can be abrogated, repealed, or cut off as bad. Then now we were speaking about the concept of right and wrong, and that's when we got disconnected. And then we spoke about the purpose of law is to protect the legal right of every citizen. And we spoke about different type of rights, right to life, right to freedom. And we spoke about how Salmon has defined the right. He spoke of it in terms of interest that is protected by law. Hofield defined right as an interest that is protected and enforced by law. Then we spoke about different types of rights, positive and negative rights, rights in rem, rights in personam, propriety, and we were doing here proprietary rights. We reached up to proprietary rights, pertaining to property. We finished this as well. Points out to value and personal rights are associated with individuals such as reputation. Example, we said that defamation, right not to be defamed, or right not to be inflicted with the harm and injury of defamation. That is, every person is entitled to a good reputation, and anyone who harms the reputation of a person is entitled to claim compensation under the law of tort. And in certain countries, just I'm trying to explain to you, or rather reiterating as it was reiterated in the earlier class in the other subject, the law of tort, saying that sometimes defamation is a crime, that is, it is a criminal offense, as well as it will be considered as tort depending upon which country it is. Example, in Australia, in some parts of Australia, it is a criminal offense as well as it is a civil wrong. So you can file a case even as a civil offense or a criminal wrong. In India, for example, it is both, and a person, if he wants, he can file a civil case as well as a criminal case. Now, Hofield's theory of rights. Hofield referred to rights in terms of liberties and no rights. We said no right, that means which does not give, it does not impose a duty, is a no right. Example, you have right to travel the world, but it is not a duty to travel the world. Then I think this is a slide which you were stuck up with. So Hofield also spoke in terms of powers conferred and liabilities to comply. So he further classified rights in terms of immunities and disabilities. Immunities and disabilities. For example, we know that for us to travel across the globe, you need a valid passport. However, there are certain people who do not require a passport. For example, Her Majesty the Queen. She does not require a passport to come to India. She does not require a passport to travel to, say, Australia or any other country, because she enjoys that immunity. Okay, so that is a different kind of a right. That is kind of the sovereign right she has gained. So he further classified rights in terms of immunities and disabilities. Now, having a diplomatic passport is a different matter. It is for at ministerial level. So they hold diplomatic passports. So there are certain immunities, privileges, and disabilities. So immunities that empower a person to enjoy privileges under a law. Disabilities are those factors that impede the performance or restrict the performance of something, and in turn may provide a concurrent right. Example of a disability right is a time-barred debt. Do you understand? Time-barred debt. Suppose A owes B $50,000, and B fail and A tells B, I'll give you $50,000 in times of your need. However, you'll have to pay me back within 1 year. And if you do not pay me back, I got the right to sue you. B says, of course, I will pay you back. But 1 year passes, he doesn't pay back. 2 years passes, he doesn't pay back. 3 years, 4 years, and then it happens to be 25 years. And finally, now A's children say, why didn't he pay you back? Let us file a case against him. Now it becomes a time-barred debt. So in law, you have the law of limitation, and according to the law of limitation, any suit to be filed for whatever matter, there are different time limits. And in case of debts, there is a particular time limit. Any debt which is time barred or which is too old to be collected and which cannot be enforced by the court, it is called as a time barred debt. Now here the legal maxim that best fits into this concept of disability is nemo dat quod non habet, which means no person can transfer a better title in property than what is possessed by oneself. This let's move on to the concept of justice, which is also an important principle under which laws are enacted. This is also one of the principles for which law is enacted and the principle that revolves around making of laws. So Plato defined or he opined rather that justice lies in virtuous action. And Aristotle regarded justice as a fairness tool to be used among individuals and developed ideas of distributive justice. He also attached significance to retributive and corrective theory of justice. We'll see what is retributive theory and corrective theory. Now, justice may take different forms. It may be corrective in nature. See, when laws are there and, laws are broken and then you are punished by the law, that the theory of punishment also takes different shape. The purpose of punishment may be corrective in nature, or it may be retributive. Sometimes, it may be deterrent in nature. This is mostly in case of criminal law, where the offender is punished with the intention to bring about a change and correct the offender. So that is corrective theory of punishment, or justice may be corrective in nature, where the offender is punished with the intention to change and correct the offender. For example, this is normally in juvenile cases where people are below age 18. They are not sent to normal prisons. They are sent to juvenile prisons. And the matter is also handled by juvenile courts, depending upon what is the type of offense that is committed. Say 11-year-old boy, there are instances, there are cases which the courts have handled where an 11-year-old boy has indulged in an act of rape, and then he was actually handled by a juvenile court. So then they sent him to a juvenile prison with the intention to correct a person. So there are different kinds of crime that are committed these days, even by children. So that is the offenses which are committed by children are handled by juvenile courts. Next is retributive justice. Retributive justice may be delivered to punish the offender proportionate to the crime committed and to the extent that cost the offender. Now, next we have is restorative justice. Restorative justice is a justice rendered with the aim of rehabilitating the offender. Again, deterrent justice, deterrent is to deter a person from doing it. Deterrent justice is the form of judgment that is delivered against an offender under law so as to deter a person from committing such offenses in the future, probably like levy huge amount of fine, which the person keeps paying throughout life. So that's like a deterrent form. Even the other imprisonment and all that is a deterrent form of, justice. Next is the concept of equity. Now, the principles that we studied earlier, if you have the subject called criminology, which is different from, the normal criminal law that you study. Criminology talks about the offenders, how, what are the different theories that revolve around, the penal offenses or crimes that are committed. What are the different theories? What are the theory of punishment? That's criminology. So if you're studying criminology, you will study this in detail if you're already studying and do not know well. So concept of equity. Equity is an egalitarian concept, okay, that points out towards equality under law. So principle of equity attracts fairness and justice on equitable grounds, and thus under law provides equitable remedies. So equity and good conscience are the two principles that complement each other and are used in law. Now, equity is normally used in the English common law system. There is a separate, it's not really codified or written down, but sometimes the principles of equity are used in adjudicating matters before the court. It's not necessarily like what is written down. So principles of equity and good conscience are sometimes, used in adjudicating matters before the court. Next, we have punishment for omissions. Certain omissions are punishable by law. Example, deserting aged parents or not taking care of them, deserting children after giving birth. So certain omissions are punishable by law. Lord Macaulay, he maintained that certain omissions should be punished under law. So what we said that, for example, what is a offense? There is an offense of commission and omission. You do something or you don't do something, it can become an offense. That is, omit to do something. Even in tort as a civil wrong, we learned that to do something or not to do something, act of commission, act of omission. Lord Macaulay maintained that certain omissions should be punished under law, but only if in two conditions, if two conditions are met. One is that first, an omission should be punished only if it has caused harm or is intended to cause harm or is likely to cause harm. And secondly, an omission should be punished only if it is prima facie, that is on the face of it, or as you see it directly, it is illegal. So Lord Macaulay was actually a famous historian and a politician who also drafted the Indian Penal Code. That is, which talks about a list of offenses for which there are punishment in simple terms. The Indian Penal Code talks about offenses and the punishments that are given to under it. Example, you have section 300 and 302, which 302 basically, which talks about punishment for committing murder. And he has worded as culpable homicide amounting to murder. So there are two types of culpable homicide not amounting to murder, and culpable homicide amounting to murder. So this was, he's in fact, as a student of law, I appreciated the way the Indian Penal Code is drafted because it's quite rich in its content, and it was actually done by Lord Macaulay. So this is all for today. If you have any questions, just ask me. Your attendance.